In today's video, we're going to be talking about a recent decision that came out of a trial court, a U.S. District Trial Court in Illinois. And this directly relates to felons in possession, or as some people refer to it as, a violation of 922G1. But to be quite candid with you, our society has become so incredibly bureaucratic and, with this massive overtone of regulation. It is very, very easy for someone to be convicted of what we call a status crime. They don't think of themselves as being criminals, and arguably speaking, most of society would not see them as being criminals. And yet the government would view them as a criminal nonetheless and strip them of specifically enumerated rights. I find that to be wholly objectionable. Now, as many people know, if you are a felon, or more importantly, if you have been sentenced to a jail sentence that exceeds 1 year, even if it is a misdemeanor in the state that you were convicted of, if you've got that year and a day requirement, then under 922G1, you now have a lifetime prohibition on firearms ownership. Now, this is pursuant to the 1968 Gun Control Act. And for those of you who have seen the videos on Bruin or have read the Bruin decision, you probably are instantly recognizing that this might in fact be unconstitutional. And in fact, it has been considered unconstitutional by several judges, let alone Amy Coney Barrett, who sits on the U.S. Supreme Court. Famously, in a dissenting opinion when she was an appellate court justice in a case called Cantor v. Ohio, she said that civil rights did not have a virtue test associated with them during the time of the ratification. In that particular case, Mr. Cantor had been convicted of mail fraud and wanted to own a firearm, and he was prevented, obviously, from owning a firearm since he was now a felon. He sued and ultimately lost, but in her famous dissenting opinion, she said he shouldn't have. All right, the reality is that there were people back during the time of the ratification that had criminal backgrounds, and they weren't stripped of their Second Amendment rights. So now we move on to this case of U.S. v. Cherry. Now, Mr. Cherry is a felon. Apparently, at some point in his past, and the record's somewhat unclear on this, he engaged in criminal conduct that essentially gave him felony status. And it would appear, interestingly enough, just from the footnote on page 1, that his felonies were potentially dangerous felonies. It wasn't like he was engaged in some sort of mail fraud like Mr. Cantor was. Well, he is suing, or actually in the case, I believe he actually is fighting a conviction of being a felon in possession of a firearm. Now, interestingly enough, the judge in this case is an Obama-appointed judge. Her name is Yandel, Judge Yandel. And she has done a faithful Bruin analysis. You little sidebar for a second. You've probably, if you've seen my videos, you've probably have heard me say before in the past that the one thing that kind of holds our nation together is predictability of judicial outcomes. We might sort of tangentially look at a case and say, it's before a liberal judge, therefore we're going to get a decision that upholds liberal values, or alternatively, it's before a conservative judge, and we're going to get a decision that, is based on conservative values. This is massively dangerous when your case is dependent on which random judge gets selected for it. You cannot have predictability, right? You're going to be nervous about making contracts. You're going to be nervous about engaging in certain conduct. You need to have, irrespective irrespective of who the judge is, you need to be able to have some ability to be able to forecast an outcome. In this particular case, the judge has given us just that. Even though she is an Obama-appointed judge, she looked at the admonitions that were given to her in Bruin and went through a legitimate analysis. The court said, okay, the first thing that the state is arguing is that Mr. Cherry is not protected by the Second Amendment. He is not the people. Remember, the Second Amendment protects the right of the people to bear arms, and the people are law-abiding citizens. And the state argues, well, he falls outside that group. He's not a law-abiding citizen. He's a felon. Therefore, he's not entitled to Second Amendment protections. The judge goes through a fairly detailed analysis and says that isn't simply going to cut it. The state has to show that there is a long-standing tradition of barring individuals that are felons from being in possession of a firearm, from essentially exercising their civil rights. And back at the time of the ratification, there were felons that still had access to firearms. So simply making it ad hominem statement that the people do not apply to the defendant is simply not going to work. She then goes and shifts the burden to the state, where they go through the history, text, and firearms regulatory traditions requirement. And the state makes the argument that there have been groups of people that have been barred from being in possession of a firearm. Even though the Second Amendment might potentially apply, they're not allowed to possess arms, not so much firearms, but arms in general. And they start citing all of these racial and religious bigoted laws, disarming Catholics, or disarming mulattoes, or disarming slaves, things like that. And unsurprisingly, she says those have absolutely no dispositive value whatsoever, claiming that a discriminatory law, even though it was discriminatory, still shows that the government can engage in that conduct is simply not going to fly. So in the final analysis, she dismisses the case against Mr. Cherry. This is right now simply at the trial court level, which means it doesn't have any controlling legal authority. Even though it's within Illinois, it doesn't bind any other courts. It's persuasive, and another defendant could cite to it, but a court is not bound to follow her decision. That notwithstanding, if the state appeals, when I say the state, I mean the government, if the government appeals this decision, it goes up to the appellate court, and the appellate court sustains her ruling, that then becomes actionable law. That now controls all of the lower courts in that district. It also, interestingly, could create a circuit split, which would then go to the Supreme Court. So if you are concerned about, whether or not a individual who might have been convicted of a felony or a misdemeanor that had a jail sentence of over 1 year, is going to be able to possess a firearm, this does not give you your card to go get one, but it is a step in that direction. We'll have to ultimately see what happens, but it's a good step. There's no question about that. Not that I am advocating for dangerous persons to be in possession of firearms, but to be quite candid with you, our society has become so incredibly bureaucratic and, with this massive overtone of regulation. It is very, very easy for someone to be convicted of what we call a status crime. They don't think of themselves as being criminals, and arguably speaking, most of society would not see them as being criminals. And yet the government would view them as a criminal nonetheless and strip them of specifically enumerated rights. I find that to be wholly objectionable. So we'll have to see how this ultimately does play itself out. As always, if you would like to contact me, you can do so at stephen@artemishq.com. And as always, train constantly, train consistently, train repetitively, and train with purpose. Above all else, stay safe.
Now, before you go, if you think you're using the right caliber for self-defense, think again. And you might not even know it, but your ammo could be putting you at severe disadvantage when you pull the trigger. Click the link in the description below to watch this short, unbiased video comparing the top 4 self-defense calibers and see if you end up changing handguns.